we will now proceed to our next panel, the Interagency Perspectives panel. And so as we heard this morning from Rear Admiral Bernanke, interagency interaction in the space domain is extremely important. And we saw that interplay with some of the questions that were asked with respect to Space Force, US Space Command, and NASA, among others. But it's not just those three organizations within the US government that work on space-related issues. And so we are now going to turn to our, like I said, Interagency Perspectives panel. It's going to be moderated by Ms. Deborah Plunkett of the Office of Air Force General Counsel. Ms. Plunkett is the Director of Aviation and Space Law at the Office of the General Counsel, US Air Force. And in this capacity, she advises the Secretariat and Air Staff on international legal issues and is also responsible for managing a subject portfolio that includes a wide range of legal topics, including state aircraft operations, the international and domestic law applicable to activities in, to, and from outer space, arms control, non-proliferation, export controls, the intersection of military and civil aviation, nuclear monitoring, satellite licensing, and a host of other things as well. And so, Ms. Plunkett, I believe we have you on the line. I will turn it over to you, ma'am, and the panel is yours. Thank you.
Thank you, Major. Hi, everyone. Thank you again for joining us for this afternoon's panel on interagency perspectives. The goal for this hour, I think, will be to hear about various agency perspectives, their priorities and their practices, and to learn some of the insights that our panel members can share. To the extent time allows, the panel will be speaking each to give you their background and their information, and then we'll be taking some discussion questions. For those of us attending and participating in this conference, and dialing in for this panel in particular, I imagine that we all have a common interest in space law. But I was thinking about what that means. And if you fly satellites, I imagine that maybe your focus, your day-to-day focus is on orbital activities. If you're concerned with space security, maybe your focus is on proximity, treaty compliance, and calling out bad actors. If you're in industry, maybe your daily focus is on ensuring a level playing field among spacefaring nations or preserving the utility of your investments in space. As an attorney specializing in international law, I have a tendency to think of space law in terms of our international commitments. So as the author of The Medici Effect, James Deacon, said, what you see depends not only on what you look at, but also on where you look from. He also reiterated that some of the best ideas come from when we better understand multiple perspectives. And so I hope that's what we're going to be doing today, learning to look from those different perspectives and hopefully finding some intersecting points. To that end, we are fortunate to have with us to share their space law perspectives, Mr. Craig Smith, the Acting General Counsel of the Air Force, Dr. Diane Howard, Chief Counsel for Space Commerce, the U.S. Department of Commerce, Ms. Emily Pierce, Attorney Advisor for Oceans, International Environment, and Scientific Affairs in the Office of the Legal Advisor at the U.S. Department of State, and Ms. Lonnie Gardner, Assistant General Counsel at the National Reconnaissance Office. Now, before we get started, one caveat on behalf of all of our panelists and myself. The views that everyone expresses are their own, and they do not necessarily reflect the official views of their employing departments or offices. Now, we have a pretty short period of time. We're only on for an hour, so we're going to dive right in and allow 8 to 10 minutes to each of our panel members to share their thoughts. If you would, please hold questions until the last panel member speaks, and feel free to enter them in the chat. So on to our first panelist, Mr. Craig Smith. Mr. Smith is long steeped in the military perspective, having served over 30 years on active duty in various assignments. He was the staff judge advocate for Air Force Space Command in his last active duty role. Following retirement from active duty, but before his elevation to be the Principal Deputy General Counsel and then the Acting GC, Mr. Smith was for many years the Deputy General Counsel for Intelligence, International, and Military Affairs for the Air Force, and in that capacity, also my boss. So given the unusual breadth of that intelligence, international, and military affairs portfolio, that's a bit of everything that the Air Force does, and years of directly supporting the senior leadership of the Department of the Air Force, I believe he has a unique insight into space law as it might impact all of those fields: intelligence, international relationships, and cooperation, and how it relates to airmen and guardians on an everyday basis. So with that, I hope you will please welcome Mr. Smith.
Thanks, Deb. Can you hear me?
Yes. Yes,
okay.
We can hear you, sir.
Thanks, and deeply steeped. I appreciate the introduction. Thanks to, of course, to United States Space Command for the invitation to be part of this part of the conference, and to a great panel. I've told Deb that in a way I see my role here is to be the opening act for the other panelists who have really some extraordinary experience, and I look forward to hearing from them too. I'll just a little bit of broad background that Deb touched on, just to flesh out a little bit more about me. I'm a New Hampshire guy. I went to the University of New Hampshire and to law school at what is now known as Franklin Pierce School of Law of the University of New Hampshire. As Deb said, spent many years on active duty, although retiring out of Air Force Space Command when that still existed, and that was a little while ago. But 3 years there, and then the exposure to a variety of space issues, and then also the interagency aspect of that with the Office of the Air Force General Counsel has been really a big part of my last almost exactly 8 years with the General Counsel's office. It's probably a bit useful too to give you many of you are very familiar with how the organizational pieces fit, but not everybody would be, and so I think it's useful both in terms of what we do here and then how that relates. You know that United States Space Command is relatively new, and our role is we don't give them legal advice, as you would know. In the Department of the Air Force, as of December 2019, we now have two services, the United States Air Force and the United States Space Force. And at this level, both the General Counsel's office and the Judge Advocate General and his staff advise the senior leadership both on the air side and on the space side. And so in terms of space matters, the Chief of Space Operations, General Raymond, is literally just down the hall from us here. And then also on the Secretariat that the General Counsel is part of, Secretary's staff, we also have a space policy essentially with a new Assistant Secretary for Space Acquisition and Integration, a position that also established in the NDAA of 20, but the position still not filled. And as Deb mentioned in the introduction, I guess my normal job, if normal is right, is the Principal Deputy General Counsel. Since the 20th of January, I'm the acting, and until we see nominees both, we don't have a permanent and newly nominated, confirmed, and appointed secretary from the current administration. So we have an acting secretary and other actings like me. So some overarching concepts, the importance to the Department of the Air Force and certainly the Space Force is integration. Integration in a lot of ways, but particularly with the interagency. And I think the Space Force and the department very much view ourselves as partners with the interagency and partners with international partners and many others. And that collaborative relationship is important, and it's one that I've seen in my career and certainly in the last 8 years here. One other organizational piece that might not be true of many federal agencies, but those of you who understand the Department of Defense know this, we have services like the Department of the Air Force. And while in my experience, many of the things that we'll do will have direct engagement with members of the interagency, we will do that in a collaborative and coordinated way with the Department of Defense, from the Office of the Secretary of Defense, at least in my case, with the Office of General Counsel. So it is a team approach within the Department of Defense and the Air Force and Space Force that we would engage in the interagency. From my experience, most frequently, those agencies that we will interact with, I would say the intelligence community, certainly the Department of State, and especially the Department of State in those matters where our collaborative efforts are leading to some sort of international agreement, of course. But then Commerce, and you've heard some of that in the course of the day, and the FAA, and of course many others, and they run the gamut of issues from launch safety to orbital debris. Of course, you've heard about, and I would say that we're talking about law, but we found, and it's especially true in my experience with the interagency, we are very much dealing with matters of both law and policy, and how those fit together, and recognizing the importance of it. And apart from the value of collaboration, I speak for myself, I always learn something from a perspective from another agency that I just didn't have. Some things that they would not have thought of, in whatever the context is. And so great value to the nation, and great value to the Department of Defense, I think, the more collaborative and cooperative we are. But Deb, that's my intro. Thanks.
Thank you, sir. I do appreciate that. So if we can turn to our second panelist, today we're going to be joined by Dr. Diane Howard. And prior to her current position, Dr. Howard was a vocal citizen advocate for the passing of the Commercial Space Law Amendments Act of 2004 in support of the development of innovative technologies and the commercial space transportation industry. Dr. Howard also participated in the UN COPUOS capacity building initiatives in Brazil and the Ukraine. She attended McGill University's Institute of Air and Space Law, completing an LLM focusing on private space law issues, and doctoral work, which focused upon effective spaceport regulation. Among other things, in her current capacity as Chief Counsel, Dr. Howard is working on the Office of Space Commerce's implementation of Space Policy Directive 3, that's the Space Traffic Management Policy. Dr. Howard is also helping to develop a transdisciplinary program examining the challenges to the space environment through law, policy, engineering, and science with the UT Austin Strauss Center for International and Security Studies, where she is also non-resident scholar while also serving as an adjunct professor in its law school. So with all of that going on, we're exceptionally lucky that she was able to join us today. Please welcome Dr. Howard.
Thank you for that lovely introduction, Deborah. And also thank you so much, U.S. Space Command, for inviting me today. Can you see me? Am I okay? Yeah? Okay, wonderful. So I think that kind of told you enough about me. I will say that I absolutely agree with the speaker right before me. That one of the wonderful things about the interagency is that it is just by its nature transdisciplinary, and clearly I have an interest in transdisciplinary studies and initiatives. And what's also very interesting, and I have to agree with him, the things that we do with space really sit at the cusp of the law and policy, and then there's always this underpinning this role of technology in there. So I thought I'd give you a little bit of a brief overview of my office, because Office of Space Commerce, what the heck? So I'll tell you a little bit about, we're not brand new. Actually, we were formed back in 1988, quite some time ago, to sort of help address issues that were coming up with the industry, which was just beginning back then, the commercial space launch industry, but also creative endeavors like privatizing MIR were starting to come up. And so, kind of trying to navigate through the executive branch was becoming a bit more cumbersome than had been anticipated. And so this office was convened in the Department of Commerce back then. And in fact, one of the original people that was involved in it is a person who's very involved in commercial space and public-private partnerships, and that's Jeffrey Mamber from NanoRex. So We've been in existence for some time. We've gone through different permutations, different places within the very large Department of Commerce. But we really were revitalized back in 2015. There is a law, the Commercial Space Launch Competitiveness Act of 2015. It's a very large omnibus law, but Title III actually changed our name. It had gone through a few name changes, changed our name back to the Office of Space Commerce. And prior to that, we had, internal policy documents that set the objectives. It's not unusual in the federal government. There's documents for most everything. But this law actually took those policy objectives and goals and codified them. And so that's a wonderful thing. So some of those policy objectives and goals are quite broad and allow us to do many things, but those things also really work best when they're done in concert with our executive branch colleagues, but not only. So the speaker on the panel right before us, my friend and colleague, Matt Moraine, mentioned something about the FCC and how the FCC is independent. It sits outside the executive branch. This is true. And so, but we include the FCC in discussions because it's absolutely the truth. Particularly in the US government, there are many different places within the government as a whole where space is an issue, an enabler, or something that we regulate. So we really, in order to be the most effective government that we can be, we need to be working together. And I have to agree again with the speaker right before me. We all do bring fresh perspectives, and because every department and agency has its own equities and its own interests, and everybody has their own perspectives, which is a good thing. This is how we avoid groupthink. So I thought it would be interesting for you if I could give you a couple of examples, like case studies, if you will, of how space law has become useful to me in my interagency work in the past couple of years, and the different kinds of, sometimes it's, domestic law, sometimes it's something that's specific to the US, sometimes it's international space law, something that comes from the treaties, and sometimes it's a combination thereof. And in one instance, even some things that I learned watching some very seasoned diplomats at UN Copious. So there's some space diplomacy tools in our kit that are useful in this context as well. So the first thing I thought I'd talk a little bit about is some of the work last year on the executive order on encouraging the use of space resources, which was followed very shortly thereafter by the Artemis Accords, which are bilaterals that are founded upon the Outer Space Treaty, but really are a beautiful example of articulating principles, transparency, interoperability, but they build upon the Outer Space Treaty, in particular Article 9. And so having a good understanding of the Outer Space Treaty, and in particular Article 9, and some understanding of the different ways that very long article has been parsed, was very, very useful in that context. But not only, because a certain understanding of some terrestrial law also was helpful in making sure that our contributions, which are equities and interests, are about the private sector. And there certainly is a role in the Artemis Accords in particular, but certainly when you think about space resources, it's not beyond the pale to think that there's a role for the private sector there. So how do we manage those relationships in these new evolving activities? So contractually. And so that's another place where law came in to the fore between like NASA or other implementing agencies and the private sector. And then understanding also from international law, this is something Deborah probably can embrace, the hierarchy of norms, understanding the legal effect of different legal instruments and how they interplay with one another. So I think that gives you some understanding of in that context. But, there's in my introduction, it mentioned that I'm on the team that works to implement the US Space Traffic Management Policy, SPD3. And that's a great example of where you have technology, policy, and law all working together. But that's another example, because there's a lot of interesting places where, in fact, regulatory theory comes in. Are we ready to be managing? Are we ready to be enforcing? Are we at that point? Are these mature enough activities, or are these dynamic? And are we still taking in information and data points? Are we better? Is it more effective and better for us? And I posit that it is better for us to be right now working on better planning and coordination activities and improving the kinds of data and the kinds of decision aids that are available, and figuring out ways to work on those data rights issues that Matt was talking about, and to work on honing the agreements. Certainly we have very, very good examples in the SSA sharing agreements, and that was a starting place for us. But another understanding in all of this was understanding what our authorities are. So how do we interpret the things that are given to us when our office was codified, but also to the department writ large, and how does that translate to help us fulfill that mission? And certainly understanding, once again, terrestrial, how do we draft a really clear, effective instrument to protect the roles and the responsibilities and the rights of the parties to these agreements for, provider agreements and sharing agreements and user agreements, and how do we make sure that we really have thought about the costs, the risks, and the benefits, and even there's an MOU that my office worked with the U.S. Space Command for many long months, and I'm not quite sure where it is, but working on, getting very clear about what the roles and responsibilities are as we help this transition from DoD providing SSA data and notification to us providing these things. And my office is currently in the process of working on a prototype to demonstrate to Congress that we're asking the right questions. Lastly, I thought I would address another one, which is, the National Strategy for Planetary Protection, which came out last December 2020. And when I say planetary protection, I am not talking about asteroids. I'm not talking about near-Earth objects. I am talking about forward contamination and backward contamination. So this really required a deep dive into those authorities of all the different departments of agencies, really understanding that's US law, but it's space law, it's domestic space law. And so really having a clear understanding of what we all bring to the table, because really we're better together, and we really need each other in order to accomplish the monumental tasks that are ahead of us, chief among them space safety, but certainly also we want to not impact science in any sort of an adverse way. But also understanding the Committee for Space Research, COSPAR, which is where the planetary protection policy comes from, and what its relationship is to the United Nations Committee on Peaceful Uses of Outer Space, and having a clear understanding of Article 9 from the Outer Space Treaty again. But I have to tell you, in this particular context, because this interagency was a little unusual from most of the ones that I've worked on, in that it brought in a number of departments and agencies that aren't typically in the conversations about space. For instance, the Department of Justice was there, and CDC was there. So a number of different, and so when you talk about, having different perspectives, it's almost like different cultures from each of these. And so that's my example of where space diplomacy really came in to help, as we, all learn to listen to one another and understand that the words don't always mean the same thing. So let's get down below that and find out what the ideas are. So I think I gave you 3 examples that are very different from one another, but really do show that there is a lot of places that space law and also a working understanding of the policy and some of the technical aspects really do come in handy working in the interagency. And I don't think that we could do our job in the government without the interagency. I think that again, it's the strongest, most robust way for us to have a fully formed way forward on most any issue. Thank you very much.
Thank you very much, Dr. Howard. Especially a personal thanks for your hard work on planetary protection, having just recently reread the Andromeda Strain. That work on forward and backward contamination, I'm really glad that you're on it. Thank you. So time to welcome our third panelist, Ms. Emily Pierce. Ms. Pierce is Attorney Advisor for Oceans, International Environment, and Scientific Affairs in the Office of the Legal Advisor at the U.S. Department of State, where her practice includes advising on space law issues related to national security use of outer space and Earth applications. Ms. Pierce brought with her to her current assignment the unique perspective gleaned from serving for several years as a lawyer diplomat at the U.S. mission to the United Nations in New York. In that capacity, Ms. Pierce provided expert legal advice on UN procedure, negotiated Security Council and General Assembly resolutions, and delivered U.S. statements on legal topics. Ms. Pierce previously completed a coveted assignment detailed to the National Security Council staff, where she advised on ethics and political activities. She is also an adjunct professor at the George Washington Law School, co-teaching international organizations law. Can't think of a better person for that. With that, over to you, Ms. Pierce.
Thank you, Deborah, and thank you to US Spacecom for the invitation to participate on this panel. It's a real honor to share the virtual stage with such an experienced group of attorneys. I'll just reiterate that the views presented here are my own and do not necessarily reflect the views of the US Department of State or the US government. I'll start with a general overview of the Department of State's space-related activities, then discuss the Office of the Legal Advisor's role in advising on these issues, as well as how we participate in the interagency process. The U.S. Department of State, as I'm sure you're all aware, is the department within the executive branch that leads U.S. foreign policy and international relations. And just to give you a sense of the scope of and size of the department, we have 13,000 foreign service members, 11,000 civil service employees, and nearly 45,000 locally employed staff that are employed at 270 diplomatic missions all around the world. And given the main purpose of the U.S. Department of State, our space-related work is obviously focused internationally. We have two policy bureaus that have distinct but overlapping focuses in the space-related field. Broadly speaking, these are the peaceful uses of outer space and space security. So first, we have the Bureau of Oceans and International Environmental and Scientific Affairs, OES, that houses our Office of Space Affairs. And the Space Affairs Office leads the department's diplomatic efforts in pursuit of U.S. leadership in civil and commercial space activities, as well as to enhance understanding of and support for U.S. national space policies and programs. The office represents the United States in international forums, in particular, the United Nations Committee on the Peaceful Uses of Outer Space, UNCOPUOS, and it works to negotiate outcomes in these forums that are consistent with US interests. The Space Affairs Office also leads in negotiations and bilateral and multilateral engagements to pursue economic competitiveness and works to build a coalition of like-minded countries to advance space commercialization, enable space science and exploration, provide resilient space services, and promote the responsible use of space by civil and commercial actors. The Office of Space Affairs is also part of the interagency process that reviews requests by commercial actors for launch licenses and other space activities. And working with us in the Office of the Legal Advisor and other bureaus, OES advises the FAA and other regulatory agencies about whether proposed commercial activities are consistent with our obligations under international law, as well as our foreign policy interests. So we have OES, and then we have the Bureau of Arms Control, Verification and Compliance, ABC, that has the Office on Emerging Security Challenges. And ESC is the lead in developing the department's positions to enhance space security. ABC supports the United States efforts in the Conference on Disarmament in Geneva, the CD. And this international forum is engaged in negotiating arms control measures. And it also has an agenda item on the prevention of an arms race in outer space that everybody is familiar with, the PAROS initiative. And while this body hasn't done a whole lot of negotiating on this issue since 1996, Russia and China have submitted a draft treaty on the prevention of the placement of weapons in outer space, the PPWT, and I don't have to tell all of you that the United States does not support that initiative. Some of the other international forums in which ABC participates have space-focused agenda items. We have the UN General Assembly's First Committee, which is one of the 6 main committees of the General Assembly, and it focuses on disarmament and international security. And then we also have the UN Disarmament Committee, the UNDC. And this is the place where the United Kingdom is advancing its initiative on reducing space threats through norms, rules, and principles of responsible behaviors. And this initiative is designed to facilitate the development at the UN of voluntary, non-binding norms of responsible behaviors in outer space. 164 countries voted to support this General Assembly resolution to advance this initiative in December of 2020. And there were 12 countries who are affectionately known as the Dirty Dozen. In the committee, we're talking China, Russia, Iran, the Cubas and Venezuelas and Syrias of the world voted against it. ABC also leads dialogues with allies, partners, and competitors. And you may have noted in the news the recent meeting that we had with the Russians on space security, for which Lieutenant General John Shaw, the Space Command Deputy Commander, participated. So how do lawyers fit within this foreign policy and diplomatic work? The Office of the Legal Advisor, which is known as just L in the department, supports all legal aspects, domestic and international, of the department's work, and that includes all of the space work. We have a legal advisory role through which we advise policymakers on the legal availability of the options they're considering, as well as helping them to conceive of possible options within the international legal framework. And then, as Craig noted, we also have a legal policy role to play in which we help to advance the development of international law and non-binding norms and guidelines of behavior. With respect to space issues, we have 2 lawyers who handle space law as such. We have the incredibly experienced Gabriel Swinney, my colleague, who I'm sure you all have had the great fortune of working with. He's been working on these issues for many years. And then there's me, who is sort of the newer kid on the block. I handle space security and Earth applications, and Gabriel literally handles everything else. And he's also the head of delegation of the US team at the legal subcommittee at Unclassified that Deb was mentioning earlier. And one of our main roles is to advise on the rights and obligations of the United States under the main space treaties, in particular the 1967 Outer Space Treaty, which with 107 states parties is the backbone of international space law and diplomacy. And we work to ensure that all US statements on and activities in outer space are consistent with those obligations, as well as with our obligations under the Liability Convention and Registration Convention and the Rescue and Return of Astronauts and Space Objects Treaty. And as with most lawyers serving clients, our work is entirely driven by the policy goals of policymakers at the department. But we work in a few key areas. One, we help policymakers prepare for the United States participation in the international forums like Unclassified and the UN General Assembly committees, reviewing draft proposals and statements, not only to ensure that they are consistent with our legal obligations under international law, but to flag potential domestic law implementation issues that need to be flagged for our other partners at other departments and agencies, so that they can provide the guidance that we need in the negotiations, and we can have a sort of whole of US government approach. We also focus on negotiation of space cooperation agreements and other international agreements. We work closely with our treaty experts in the Treaty Affairs Office within L to ensure that state and other executive branch policy clients have the authority that they need in order to negotiate and conclude these agreements, as well as to ensure that the substance and form of the agreements are consistent with our vast general international treaty practice across all areas. Our treaty experts also help us to ensure that the Senate Foreign Relations Committee is kept in the loop at appropriate times, especially if we're talking about an agreement that would require the Senate's advice and consent, or any agreement that we would need to notify to the Senate consistent with the case Zablocki Act. Finally, we support development of diplomatic strategies to help the United States implement our legal obligations and our voluntary commitments. So, for example, right now, after the White House recently announced that we were going to continue the Artemis program, as well as continue support for the Artemis Accords, which, as Dr. Howard mentioned, are a multilateral declaration negotiated under US leadership during the last administration that provides non-binding guidance on implementing our OST obligations, facilitating responsible behavior in space exploration. Gabriel is working closely with our policy colleagues in OES to help devise strategies and to promote the accords and encourage other countries to join. But because the issues are so cross-cutting, Gabriel and I have to reach back to other lawyers in L who are experts in other areas of international law that apply in space or that are space adjacent. So we frequently draw on the expertise of, we have an expert in the International Telecommunications Union, the ITU. We have an expert in ICAO. We have law of war experts, and we have arms control experts who all need to feed into the policy objectives that our clients are working on. And then finally, with respect to how we engage with the interagency, much of the work I've already been describing involves a considerable amount of interagency coordination. A few additional examples are the department participates in the space policy deliberation process run by the White House to ensure that the policy developments account for our international legal obligations as well as our foreign policy considerations. And informally, State L has hosted an interagency, a group with with relevant interagency lawyers to help support the work that the White House group is doing. And of course, in the previous administration, that was done through the National Space Council, and it sounds like from recent reports that council's work will continue in this administration, which is great. The State Department also leads US delegations in negotiations on the development of non-binding commitments on space sustainability and security at UN COPUOS, the General Assembly, and other multilateral forum. And significant interagency coordination is needed to help ensure that the State Department is putting forward a whole of US government views at the negotiating table. We also need to ensure that we're consulting with industry and other stakeholders. And one notable current effort is the development within the interagency of the US input that will be submitted next month to the UN Secretary General to inform the discussions in the General Assembly on the UK's initiative on reducing space threats through norms, rules, and principles on responsible behavior that I mentioned earlier. So that input's due in May. And then third, if the Departments of Defense or Commerce, NASA, or the FAA are coordinating draft public remarks made by one of their principals that touch on, make statements about international law in relation to space, then Gabriel and I would likely receive an email from one of our interagency counterparts asking us to take a look and review the remarks. We like to make sure that our statements about international law are consistent within the government. And in State L, we have a really wide view on all of the statements being made about international law across departments and agencies. So we're sort of the the hub for reviewing statements about international law. We also work with DoD, NASA, and Commerce on negotiating, revising, renewing, extending, and amending the numerous space cooperation agreements and MOUs that we have with other countries. And we also review space-related rules and regulations during the rulemaking process to make sure that those rules are consistent with our international legal obligations and foreign policy goals. And then I'll just mention in the space security area that state works closely with NSC and DoD and other interagency partners to discourage irresponsible behavior in outer space by other countries. And this was evidenced by our close cooperation with US Spacecom in sending a demarche to Russia regarding its placement of a satellite in close proximity to a US government satellite. And the Secretary of State, during a major speech to the Conference on Disarmament, also urged countries that are developing anti-satellite weapons to refrain from dangerous testing of such weapons. So here, of course, states' obligations under the OST, as well as non-binding commitments and guidelines related to space debris mitigation are important and relevant. So I'll stop there and send it back over to you, Deb. Thanks very much.
Thank you, Ms. Pierce. And in particular, I just wanted to point out that your office has always been amazing at making the most of those opportunities for intersection. I think you and I may have discussed this recently, but when we had to do interagency preparation, the delegation guidance, when we would have to pull that together for UN COPUOS every year, we'd have a series of meetings all hosted by LOES that allowed us to talk not only about the big issues that we were going to bring up and discuss at UN COPUOS, but like you said, all of that backward advice that we had to be prepared to advise our agencies on how implementation was going to work, and so that we could also crosstalk with state about challenges for potential implementation. And I've always found that to be really valuable connection. So, and thank you again. With that, I hope we can turn to our fourth panelist, who is Ms. Lonnie Gardner. Ms. Gardner, in her practice as Assistant General Counsel at the National Reconnaissance Office, the NRO, she advises on space law and policy matters. And interestingly, in addition to that broad remit, Ms. Gardner also advises the NRO's Aerospace Data Facility, Colorado, and the NRO's Management Services and Operations Directorate regarding environmental, health, and safety matters. Ms. Gardner comes from a scientific background herself, and she achieved her bachelor's in chemistry before pursuing her JD. Ms. Gardner also has a Master of Environmental Management degree from Yale and a Master of Science and Technological Intelligence, MSTI, from NIU. Ms. Gardner, I'm grateful that you're here with us. Among the different perspectives represented, I'm glad that we have someone here who is also uniquely able to speak science. Thank you for joining us today.
Thank you, Deborah. I'll just do a quick sound check. Hopefully you can hear me.
Yes, we've got you.
Excellent. I appreciate, first of all, for the opportunity. So thank you, Space Command, for the invite. And I'll be providing some unclassified remarks about the National Reconnaissance Office, just in general, because we're relatively unknown. And I do think it's helpful for folks to kind of know what we do to the extent that I can share. Also, that'll provide a little bit of context with my particular role or the other attorney's role in the Office of General Counsel and how we help the NRO succeed in its mission. And also the context will help explain how we work with the interagency. And at a very high level, we do this through close coordination with our partners, bringing our perspective to the table. So we'll probably hear a lot about the integration and the perspective and the whole of US government, because we're really all pieces of one big fabric. So it's really important to have that perspective. Also, just, these are my views, not my organization's, Department of Defense's, or the US government. Next slide, please. So the NRO is a defense agency and one of 18 intelligence community members. The Director of National Intelligence oversees the intelligence community, and the newest member, not reflected in the group of SEALs here, is the US Space Force. And we know that, as Craig and others have mentioned, the Space Force was established within the Department of Air Force in late 2019. Next slide, please. So the NRO's mission is fairly simple. We provide innovative overhead systems for national security. Sounds easy enough. So we do this through R&D, acquisitions, launch, and operations of U.S. intelligence, surveillance, and reconnaissance architecture. And we also ensure safe end-of-life deorbit operations. While attorneys are involved in all aspects of the NRO mission, much of the work of our office relates to acquisitions, because that's a massive part of what we're doing day to day. So our attorneys advise the NRO throughout the acquisition process, including competitions, contract award, bid protests, contract admin issues, data rights issues, IP issues, all of the types of issues that one would expect from an acquisition organization. Next slide, please. But we do support, through our operations in space, a diverse mission set. We support signals intelligence, SIGINT, and the geospatial intelligence GEOINT missions, as well as support HUMINT missions. The NRO is truly the foundation of the United States global situational awareness, and we can contribute to global intelligence, military, and homeland security operations, while simultaneously our data assists with the formation of national policy, decision-making, and achieving diplomatic goals. So while we're not at the table like State Department is, our data helps support some of those diplomatic goals. Interestingly, 2021 marks the NRO's 60th year in business. In 1961, the NRO was established, and it was relatively unique. I mean, it was 1961, first of all, and it was an office established through a partnership between the Secretary of Defense, the Director of the CIA, among the Department of Navy, CIA, and the Department of Air Force. So it was a unique office that was stood up back in 1961. In 1992, the NRO's existence was declassified. And over its 60-year history, the NRO has provided reconnaissance support to the intelligence community and the Department of Defense, in large part due to our ability to rapidly harness emerging technologies and enable intelligence. And so that's what we do, and we do it rather well, we believe. Next slide, please. So in terms of how the NRO is funded, because that comes up a lot, it's jointly funded by the National Intelligence Program, the NIP, as well as the Military Intelligence Program, the MIP. And all funding priorities are established by the DNI, as well as the Undersecretary of Defense for Intelligence, acting on behalf of the SecDef. Both the DNI and the SecDef exercise joint oversight over the NRO. So it's great to have two bosses. The majority of our budget goes toward the acquisition of satellite systems. And as mentioned, a significant portion of our office's work relates to acquisitions and government contract admin. However, our office supports numerous areas of law, including litigation services involving the NRO, export, intelligence oversight, intellectual property, ethics, personnel admin law, real estate, privacy, civil liberties, environmental health and safety, space law and policy, and more. And we do this with 13 attorneys. So we all have to know a little bit of many things. Next slide, please. Our workforce is rather diverse, and we view this as a strength that enables our key missions. By diversity, in the big picture, I mean, we have folks from some 3,000 folks coming from all over the United States government, to include NRO cadre, who are DoD civilian employees, members of the armed services, the CIA, and other DoD civilian personnel, including folks from the National Security Administration, NGA, agency, NGA, DIA, and others. The NRO, kind of big picture, has a director, principal director, deputy director, corporate staff, and then 10 directorates and 3 offices. And those different directorates, have different foci, and lawyers advise across the spectrum, all the directorates and offices, as well as, the NRO writ large. Next slide, please. So, we work collaboratively within the IC and the Department of Defense. We have a special relationship with NGA and NSA, who are our mission partners. And together we support our users, who range from intelligence analysts to the women and men of the military and senior government decision makers, including the president. So kind of coming to some conclusions, for our initial, for my introductory remarks, we have had a long history with the Department of Air Force, obviously, kind of as I described, sort of how the NRO came to be, as well as the fact that a majority of our service member workforce were historically airmen, many of whom have now transitioned to Guardians now that they're members of the Space Force. Our relationship with Air Force and Space Force, remains strong, as we have many common interests with respect to the space environment, such as the freedom of exploration and navigation in space, and the use of space for national security purposes. We also have common interests with our interagency and the commercial sector regarding issues related to increased congestion in space, space traffic management issues, and space debris mitigation issues, to name a few. So those are kind of some common issues that would be of interest to all of us. And we share many of these interests with, our commercial partners as well. This concludes my introductory remarks. So thank you.
Okay, thank you very much, Ms. Gardner. I really do appreciate you being with us today. And also that's a fantastic point. I know that a lot of our listeners are particularly interested in how the NRO role, the IC community, the military community, and the State Department work together. And I know that there's a lot of interest in how your agency in particular has supported those international efforts over the years. So thank you very much for bringing that to us. So with that, we are now in segment 2 of our time together, and this will be where we get to move into some of the questions, in particular your questions. I understand that our chat function is open, and we do have some questions already. Feel free to pour in and add on to those. So if you don't mind, I will start off by pulling out some of the questions people have sent in. Jenny Naylor has asked, can you talk about trends in legal mechanisms or instruments that help foster norms of responsible behavior in space? For example, are we seeing more negotiations over multilateral or bilateral treaties, executive agreements, or political commitments? Or are we seeing more domestic law and policy development among various states that could possibly contribute to customary international law? Or are we seeing more technical standard setting type of activities? What mechanisms or mix of mechanisms is feasible to accomplish? And let's see, and with particular interest in Russia and China interest, and keeping pace with the technological development, commercial interests, and concerns about disarmament. Well, so this is a very long, complicated question that I think I would like to throw to Well, I would say probably Emily first, if you would like to take a stab at it.
Yeah, sure, Deb. I can take a stab at least part of it if I can't get to all of the parts of it. But I think that I think at least in the space context, the trend in the international plane is towards non-binding voluntary commitments, norms, rules, guidelines. I mentioned the UK initiative in the General Assembly that is underway. And then the other example that we've already talked about a little bit are the Artemis Accords. And there, the Outer Space Treaty, of course, underpins everything in the Accords. But the best way to think about it is probably that the OST tells us what our obligations are, and the Artemis Accords go on to say how the United States and our partners will implement those obligations in the civil space context. So for example, Artemis builds upon the OST by providing non-binding interpretation of what OST Article 9 do regard, what the due regard obligation is, and how activities that may cause harmful, and how that obligation can be implemented, including through safety zones where planned activities that may cause harmful interference will take place. So I think at least my view is that the Outer Space Treaty provides a pretty solid baseline from which to then develop non-binding guidelines on how it should be implemented. Keeping in mind that the Outer Space Treaty incorporates international law by reference, in particular the UN Charter. So I think we have a really good framework to move from, at least on the international plane. And I think I would defer to some of my other colleagues on the domestic front. Thanks.
Well, I can just kind of follow on to what Emily just said. The Outer Space Treaty is a treaty of general principles, and it relies on implementation and mechanisms like the Artemis Accords and also domestic law. So I think the answer to this querence question is it's a little bit of all of that, because I know also in the space traffic management arena, we really are relying on technical standards a great deal, because we're not at a point where and I made that point during my intro remarks, we're not at a point where we're ready to actually put requirements and rules in place, but we are working with the technical community. And in the US, we're unique. In the US, we have to interact with the private sector, and wherever possible, the US government is directed by statute to use voluntary consensus industry standards. So we really, I really think it's a quinella. It's across the board. It's a little bit of all of that. And I think that's good. It's a hybrid approach. It goes top down, it goes bottom up, and then there's something in the middle. Over.
Thank you very much. Does anyone else want to dive in on that question, or are we free to move on to one of the others?
Only to say, I do believe that the commercial sector will eventually play a large role in how folks behave in space. And just by sheer volume, if nothing else. I mean, these are just kind of personal thoughts, but right now there's some 2,600 or so operational satellites out in orbit, most of which are in LEO. We know more's to come. I mean, with a lot of mega constellations coming down the pike, actually 60 of the Starlink mega constellation were launched today into orbit from Cape Canaveral. So more to come. And I think that, ultimately the commercial sector will help really shape a lot of how, what you can and can't do kind of in space in terms of, some of these concepts that we're talking about. Over.
Or what you should and shouldn't do, because, when we're talking about things that are not, don't have the full force of law, we're talking about things that are soft, guidelines, principles. We're aspirational, and we are seeing that with the private sector already. I mean, there's a Space Safety Coalition that put together a list of their best practices. They're not necessarily saying that they're all going to be bound, but if they could, they would. So I think that it's not just what you should and shouldn't, but it's what you wish that you could, and I think that sort of sets the tone. So I think that that's also got great value.
one thing also that I would add, in light of Lonnie's comments, is that I think that there is sort of a need for a look at an enhanced domestic regulatory authority to cover some of the novel commercial space activities. I think to the extent that we have the framework in the Outer Space Treaty, we do have obligations there that our domestic law is sort of lagging behind a bit in making sure that we live up to our obligations with respect to effective control and jurisdiction over those activities.
I'll also add on to that too, because I think that the conversations in the executive branch are starting to address that and candid discussion. What authorities do you have? What authorities do you have? How can we put these things together? And I think some of these novel missions, maybe they're not so novel. Maybe NASA's been doing some of these things, but they haven't been done by the private sector, or maybe they're complicated missions. They're missions that have more than one aspect. And I use as an example, RPO. So you have an imaging piece, you have a comms piece, you've got a transportation piece. So I think that I think that there's more that could be done with what we have, and certainly clear and express authority in addition to that would only make it better.
Thank you. And sorry to have to jump around topic to topic a little bit, but we have a question that actually came in from a couple of different sources on the chat. And I think this one I'm going to send over to you, Mr. Smith. We've got some folks that are really keen to know when and if the U.S. Space Force will get its own judge advocate capacity. And that's how it was asked. Would you like to answer that, sir?
Sure. I guess I'll take a stab at that, recognizing it's really in the wheelhouse of the Judge Advocate General. But the idea, I guess I'd put it this way: no plan that I know of to create a separate Judge Advocate General's Corps. And the idea is that the Department of the Air Force, the Judge Advocate General's Corps is big and robust and serves both air and space, and down to the installation level. Those legal offices, which are populated by members of the Judge Advocate General's Corps, military and civilian attorneys, active, reserve, and the whole range, will continue to provide that same legal advice that they have always given, whether it's air or space. And that I would say too that from the beginning, I think Congress is very much interested in when the Space Force, United States Space Force, stood up, that there was close attention and management of the size, and that it didn't become some new and bloated bureaucracy. And I think on the legal support side, the Judge Advocate General is very conscious of that and very comfortable that the support could be provided from his core. And so I think that will remain true for the future as far as I can see. I hope that answered, Deb.
Yes, it does. Thank you very much, sir. So we have another question from the chat. And I'm going to make this, and anyone could take a stab at it if they want to question. We've got Jeffrey Parsons would like very much to know, where does detecting and tracking near Earth objects, NEOs, fit into the surveillance community in law? Maybe you, Ms. Gardner, if you know, or if you can say.
I don't know that there's much I could specifically say about that particular question. So if I could punt over to one of my colleagues, I'd love to do that.
Not at all. No problem.
Maybe commerce.
Tracking near Earth objects.
No, I have no idea. I think NASA could answer that if they were on the panel.
Something for next year then. I apologize to you, Mr. Parsons. We'll work on that next year. And so we do have a number of questions. People are curious about the NRO. So if I can keep you in the hot seat for a minute there, Ms. Gardner. Some folks want to know historically, why was the very existence of the NRO such rigidly kept secret until the end of the Cold?
I don't know the answer to that question. I just know that the decision was ultimately made, that its existence should be declassified in 1992. So the good news is, we can kind of live an open life with the rest of government. And that's really important. And the reason it's important is because we can have a seat at the table that's acknowledged, and we can work with our counterparts, at Space Command, or within the Department of Air Force, or other interagency partners in the open, because we do have an interest in whatever the particular may be. So I would say that's the advantage, but I'm not really sure on the historical piece, how things came to be.
Okay, thank you very much for that. We have another question that I think it actually could go to almost anyone on the panel today, but I'm going to think probably starting off with Ms. Pierce, if you don't mind. Question is, how does the Interagency Debris Coordination Committee plan to achieve its objective while it's based on soft law? Many parties do not have legislation in place regarding space debris. And I suppose we could also put this in context and say that we have some folks that are interested in orbital debris issues. If there's anything that the panel members want to say about their involvement in orbital debris mitigation. Over.
Yeah, Deb, sorry to disappoint on this one. Gabriel covers the Interagency Debris Coordination Committee, so I'm not as familiar with its plan. So I would have to defer to one of my other panelists.
And I think I can help parse a little bit of this out. So the IADC, which is the committee, that the organization you're talking about, it consists of space agencies. It's not, so they're governmental organizations, and they actually had a very big role in the development of the UN COPUOS space debris mitigation guidelines. So they did their work, and it was many of the same people that sit on that agency that also were delegates to the Science and Technical Subcommittee at COPUOS. And so that work got brought over to the UN COPUOS STSC and had to go through the consensus process. And yes, it's soft law, and it says so in the very beginning of it, but then it has been incorporated into some national law, and it is incorporated by reference in almost every international document. It's referenced more than once in the long-term sustainability guidelines. I think the issue isn't that it's soft law, it's that when it is even hard law, it's not complied with. And I know that the European Space Agency has done some studies to show that the compliance numbers are really abysmal. So I think even where it is, incorporated by reference into binding domestic law, it's not always followed, and it's a compliance issue. Over.
So with that, we've only got 2 more questions, and I've got a text from the organizer saying that we are a few minutes over, but they're happy with that. So we can take a couple extra minutes and continue on if that's all right with you. There is a specific question from Ms. Gardner asking, is there anything that you're able to share in an unclassified setting concerning the UAP and AATIP disclosure programs? Over.
There really isn't, and I wish I could share more information. I do have a thought though on the prior question, so I'm not sure if that's worth kind of a revisit, and maybe it really dovetails into Mr. Parsons' question that he had, and now that my wheels were turning, I could think about it a bit more. But I think just kind of related to space debris generally, I mean, if I could just foot stomp anything, it's that it's a problem, and I think it's a problem for everyone, and a massive problem for the commercial sector as they, put more out there. But also as things get more congested, that kind of increases the risk that, of collisions and so on and so forth. So, I think kind of big picture, tracking debris is a big deal, but as to who owes what obligation to whom, to inform them of what's coming, that's kind of a slightly open question, but a really important and interesting one. And just, the explosive growth of space debris just over time, that's concerning. I mean, just to put it in perspective, this fall, the International Space Station, celebrated 20 years of humans living and working in outer space. But in 2020 alone, had to maneuver 3 times to get out of the way of space debris. That hadn't happened since 2015 and has happened about 27 times since 1999. So, I think as those numbers, it would seem logical would go up over time. So that's kind of a really hard problem. And a lot of different folks kind of play a role in that.
Thank you. Ooh. Not sure if we're being cut off here. So we have one last question, and I just wanted to kick it over to the group. The question has to do with the fact that so much of existing space law is agreements between sovereigns. It's state to state. And there seemed to have been a presumption at the time that the way we would interact with each other in space was government to government. And since we perpetuated that with additional agreements at the government level, and yet we've seen so much development with non-traditional space countries, newly spacefaring nations, and a lot of commercial coalitions and commercial activities, some of which are offshore. Are you seeing any additional need for newer developments, the potential for a growth in international space law or a refocusing?
Here I could just sort of chime in, Deb, just to say or highlight what I had said before, that I think that given the way that the OST is structured, where states have international responsibility for national activities in space, and then they're required to retain control and jurisdiction of all activities, even private activities in space, that we really need to focus on closing any domestic regulatory gaps, because that's the law that's going to regulate what non-state actors are doing in space. Over.
Thank you very much.
I can chime in on that. It isn't that there is no private right of recovery under the space law framework, but there is a relationship between the state and the private sector in Article 6 of the Outer Space Treaty, and that's what Emily is talking about. And that's where there's more work to be done, because it doesn't address absolutely everything and clearly. That said, we also have 21 fantastic long-term sustainability guidelines and a great preamble that even includes a definition of what long-term sustainability in space activities means. And that was that heavy lift, but now we're in 2.0. So we're figuring out how to move forward, how to implement, how to capacity build. And there's a relationship between those two. And so there are things that are being done. The Artemis Accords you're right, it's another fantastic example. So I don't think we need to revisit, top level, hard, it doesn't look like a reality anyway, but that doesn't mean that we don't have things in our toolkit to go forward with.
Thank you, Doctor. So we are almost 15 minutes over, so I'm going to take this as our opportunity to draw to a close. And if there is, turn back to our panelists and ask, is there one thing you'd like this audience to take away from this session? Is there one issue that you'd like to foot stomp before we go? Mr. Smith?
Yeah, I'm waiting for my camera to come up, I think. No, the only issue I would foot stomp is what a great, just watching the panel discussions and the expertise is there. It was a perfect example of how the interagency works and works well. You've got, I think all of us described a relatively small cadre of really dedicated and enthusiastic attorneys who work really well together. And I think it was just a great representation of not just the importance of the interagency coordination, but how effective it is in real life. Thanks.
Thank you. Dr. Howard, can we turn back to you? Is there something that you'd like to foot stomp?
Yeah, I'm going to foot stomp what Lonnie Gardner said, and that is that orbital debris is an enormous problem. The mitigation of the creation of more debris, but also the mitigation of the effects of the debris and collision avoidance. And we just all need to really, not only should we take it seriously, we need to take every opportunity to message that out. Thank you.
Thank you, Doctor. Ms. Pierce?
Yeah, I think I just say that there are significant challenges that we're facing as a U.S. government, and As Dr. Howard mentioned, we have a lot of different tools, and those tools are sort of in the wheelhouses of different agencies and departments, and so we all need to work together. And I also just want to emphasize the problem of space debris, which I think is a key priority for the State Department in terms of interagency conversations this year to try to advance our measures in that respect. Thanks.
Thank you. And Ms. Gardner, back to you. Anything else that you'd like to add?
Only that a lot of great ideas come from a lot of different places. And so just to kind of dovetail on what everyone has been saying, you know, we make better decisions when we have more information, and we have that great opportunity when we work in coordination with each other with the interagency. So appreciate the opportunity to be involved in the panel. Thank you.
Thank you very much. So, and thank you all, our audience, for coming and joining in. We really do appreciate your interest. I myself would like to thank the panelists for a very interesting hour and the event organizers for making this happen. Thank you all again for coming. And over to you, Major.
All right, thank you so much, Deb. I echo Mr. Smith that this was really a great panel, a lot of interesting issues, and I really enjoyed the conversation. And thank you to all our presenters today. It was really fantastic and set the stage quite well for the rest of the week.